distinguished, exclusive group whom I particularly value. I was saying I really know you all by name, so that's really nice. So it might be very interactive in the end. I don't think I need to introduce either of the speakers, David or Inge, and the bios are in the program. But I think we're very fortunate to have two people here who actually, really have practical experience with drafting contracts, arbitrating contracts, and can give us a really good insight how to draft a contract with the CISG in mind. And I think we agree that we start with David and the international arbitration clauses.
Yes, I'm happy to kick things off, and I'm hoping that what we lack in number we make up for in questions and enthusiasm. So it is meant to be an interactive session, and please feel free to jump in or ask questions at any time. But I thought I would kick things off expressing kind of my thought process when I'm looking at a contract or considering how future disputes ought to be resolved in a given commercial situation. And I thought I'd begin with a few truths about corporate life. And one of those truths is that when we make decisions in business, and I think it's true right across the board, but it's certainly true in relation to dispute resolution, you try to make decisions that are defensible. That is, if you select a particular dispute resolution regime and it all goes seriously wrong at the end of the day, and it certainly could happen to any of us, you want to be able to look back and be able to say, well, here are the decisions that were made, and these are the reasons why those decisions were made. I think, again, this is a fact of corporate life that it's important to understand. Now, against that background, depending on really the sophistication and to some extent the respective power positions of the parties in a given negotiation, I like to explore when I can some more innovative and interesting dispute resolution mechanisms. My legal team at Vodafone, which consists of about 10 lawyers, but also the broader legal community at Vodafone, which last I heard consists of about 400 lawyers in 25 or so jurisdictions around the world. We have a lot of internal issues that arise, and not infrequently, if it's a matter pertaining to dispute resolution, especially arbitration, I will get the email or the phone call and will be asked to give a view. So what are the types of things that I typically consider, and why? What are the positive attributes of international commercial arbitration that I hold dear? One of them is finality. Business people, our core expertise is mobile telephony communications. It isn't resolving disputes. Disputes mean that we have to make a financial provision in our accounts for a potential contingent liability. It means plucking people out of the business to search for documents and become involved in hearings and proceedings, which takes them away from their day jobs, as it does me. And so it's a huge drain on time, money, and resources for the business. Commercial people want to get disputes resolved, and they want them resolved quickly. Now, and this is often cited in the literature around the world by the pundits as being why commercial people so favor international commercial arbitration. And a separate issue that has kind of come out of that recently, I've read some articles in literature where people are saying, well, commercial people, why don't they just flip a coin if all they want is an answer? They don't care about accuracy. They don't care about fact-finding or truth. So I want to just be very clear. I want an efficient and quick decision, a resolution of the dispute, but I also want a quality decision. And we can talk a bit about how that is achieved and what that means. Here in New Zealand, as many of you are aware, Article 5 of Schedule 2, New Zealand follows a minority view where local lawyers are very comfortable, very accustomed to having a right of appeal of issues of law. And that, of course, is the English view as well, but it is a minority view. So again, finality to me is hugely important. Also, having a voice in the selection of the decision maker is important to me. So whether it's a sole arbitrator, I want to have a voice in deciding who that individual is going to be. If it is a presiding arbitrator, I want to work with my nominated arbitrator to have a voice in selecting the chairperson, because the chairperson, as we all know, plays a hugely important role in the ultimate decision that is made. But I don't want arbitration to be merely a preliminary step on the way to the High Court or the Appellate Court. I want a final decision. Now, obviously an important decision always is seat. And for experienced arbitrators and dispute resolution professionals, we know that perhaps there's nothing more important than selecting an arbitration-friendly seat. That with sophisticated, efficient courts that are knowledgeable, specialized perhaps in arbitral issues, who will dispose of matters efficiently and quickly. But you may be surprised, or not, that when I am explaining to our directors that I propose to seat a matter, let's say in Singapore or Hong Kong, the first thought that they have, well, is an airplane full of lawyers, jetting off to remote, distant places at huge expense. And so, embedding that the understanding into the minds of the business leaders that the juridical seat or place of arbitration is so hugely critical to the procedural law and to the supervisory jurisdiction to achieving an efficient process, that it's not just about logistics and how far it is from here to there that they ought to be thinking about. Seat and venue, of course, being very different concepts. We can agree, perhaps, that an arbitration will be that meetings and hearings will be conducted here in New Zealand, even if it's an LCIA arbitration under LCIA rules, for example. And I've set up arbitrations that way with some success. Ad hoc versus institutional arbitration, of course, a key decision. I sit as an arbitrator myself in both institutional and ad hoc proceedings. I've seen ad hoc proceedings. I've presided in ad hoc proceedings that have run quite smoothly and efficiently. But would I recommend them to Vodafone? I certainly would not. And I think that the small amount of money that is paid to the arbitral institutions and their staffs for the services they provide is excellent value for Vodafone. The Secretaries General that I've had the pleasure of working with in SIIC, HKIAC, ICC, they're open and welcome to questions from less familiar, less experienced parties. They're extremely helpful. I find that they can provide a useful back channel to the tribunal when you have questions and you need to get answers. But so I just think in many ways, handling the money, dealing with the deposits from the parties, and paying arbitrator fees and invoices and the like, hugely helpful. So I can't say enough good things about the arbitral institutions. And as a user of arbitral services through Vodafone, I see Vodafone as taking advantage of the competition that's at play between the different arbitral institutions. I mean, it's big business for the institutions, it's big business for the governments of the jurisdictions where these institutes operate and reside. And as I say, I think the more these institutions compete with one another to deliver the best and most economical services, the more my company, Vodafone, gains advantage. And I should probably jump in at this point and just be clear that I'm speaking for myself and giving my own views. I'm not, my views are not necessarily those of Vodafone, either in New Zealand or elsewhere around the world. We heard earlier today some discussions about mediation and about escalation, tiered dispute resolution clauses. They are the order of the day in my industry, in the telecommunications industry. It's rare that I will see a significant contract that won't talk about escalation from the working team to an officer, a senior leader of the business. I personally think that's a good idea, to remove the people or the problem from the people and get it up to more senior levels. From there, often into mediation and then arbitration. But the point is often made, and I think it's a valid one, that I mean, I don't want to go to mediation or even really discuss settlement until the facts are reasonably well developed in a case, until and frankly, my own experience as a trial lawyer is that there has to be a bit of what is sometimes called bloodletting. The parties have to suffer a little bit and maybe get softened up a bit before they're in the right frame of mind to achieve a commercial deal. Egos are involved. I mean, needn't elaborate too much on that. So very often, in my experience, the best time to renew or go into mediation is after the case has been afoot for a while and the issues are well developed and positions become clear, and the parties may, as I say, be becoming just a bit weary of the contentious process. But in my industry, the bottom line is that escalation clauses are here to stay. And the important key to drafting them is to have clear and objectively determinable steps for moving from negotiation to mediation to arbitration, so that either party can submit a letter referring to a specific clause in the paragraph saying, we've given up now on mediation, it's time to go to arbitration, it's time to move on to the next step. And of course what you don't want is to draft an agreement that says that when the parties agree or decide that mediation is not proving effective, we can all go on to arbitration. You want a defined and indisputable event that triggers the move from one step in the process to the next step. And I mentioned in my paper, in the materials, I've plucked a few key clauses, model clauses from the IDA guidelines for drafting international arbitration clauses, 2010. It's a wonderful piece of work, and I think a very good place to start. Another very good place to start when you're choosing arbitral institutions and using their rules is to go to their website and look at their model clauses. And care should be taken, if you're going to modify those clauses, to get specialist arbitration advice before doing so. Confidentiality is a very key concern for me. In some quarters, there's a view that big companies are inherently evil. And I fear sometimes that the judges in various corners of the world share that view. Whether or not that is a concern, I can tell you that virtually everything Vodafone does or touches, when it becomes when it moves into the public realm, every man, woman, and their dog seems to have an opinion and a view and wants to write about it and wants to talk about it. And the reality of that is that it makes it more difficult for the disputing parties to work it out. And obviously our brand, as Vodafone's general counsel, protecting the brand is one of my two principal mandates. The other one is reducing legal risk to the business. But so much of the value of our business is tied up in the brand that unless confidentiality can be maintained in relation to dispute resolution, we're seen to be a company that can't get along with its competitors and suppliers, and that's not a good look for any business. So I will always be asking myself, and of course these are generalizations, and there are instances where you want to be very much in the public eye, and you may want to be in the high court. But here in New Zealand, I do have concerns that we have some of the most sophisticated provisions in our newly amended Act for confidentiality in arbitral proceedings, but as soon as either party takes the matter off the track and into the high court, then justice in the sunshine becomes the default provision, and we have a very high bar a high hurdle to cross to persuade a judge to impose or to require confidentiality. Of course, we can put it in our agreement in the first instance, and we'll try to do that in most cases. But the reality is, you've got people in all parts of the business at all kind of levels of experience and capability drafting disputes clauses. That's the reality. And if something finally does go into dispute, you may find yourself blowing the dust off a commercial contract and seeing that the disputes clause doesn't provide for confidentiality and may not operate the way you ideally wish it to. Finally, flexibility. I think the flexibility and the ability to look for creative solutions to disputes that fit the needs of the particular commercial relationship and future disputes is a key attribute of arbitration. And so if I do pull a commercial document down from the shelf and blow the dust off and find that the disputes provision buried deep in that contract is pathological, it simply doesn't work, I won't hesitate to meet with my opposing general counsel and spend whatever time it takes to see if we can amend that agreement and possibly prepare a submission agreement and a more appropriate and efficient dispute resolution process that will make both parties happy. Just touching on a few other areas of concern. Do I want one or three arbitrators? Most of the literature that I've looked at that's backed up with facts and numbers suggests that you do not necessarily get a better result with three arbitrators rather than a sole arbitrator. We all know that if you have three arbitrators, everything is going to be much more costly and time-consuming. My own view, and this is again a personal and biased view, if the matter is highly strategic and the numbers, the dollars are very large, I won't hesitate to go to three arbitrators. At the drafting stage, I think I would optimally like to say the dispute will go before one or three arbitrators, which I believe is the language that the ICC model clause, among others, utilizes, so that we can wait until a dispute actually crystallizes and then have a chat. Is this more appropriate to go before a sole arbitrator or a tribunal of 3? So I don't see that as a huge issue or a highly contentious issue, but I think if given the choice, I will usually be happy to go with a sole arbitrator, provided I'll have a voice in selecting him or her. IBA rules of evidence, we've heard a lot about the soft law of arbitration. I personally, when I'm sitting as arbitrator, I like to include in my directions that I may be guided by the IBA rules. I don't necessarily want to be wedded to them, that I'm required to follow them to the letter, but I believe, personally again, that the IBA rules of evidence have become a bit of a procedural lex mercatoria and have set a bit of a watermark globally for international commercial arbitration procedure that helps commercial people anticipate how their matter will be handled and brings certainty to the process. Finally, my own experience, and I wouldn't want to put any finer a point on it than that, but in an earlier session there was some discussion about the fee schedules that are used by the High Court here in New Zealand. My own experience, again, is that if I'm the successful party, and I intend to be, and if I'm going to recover my fees in the High Court, I'm very often disappointed by the amount that actually comes back when balanced against the amounts that have been spent. And conversely, in the matters that Vodafone has arbitrated, we have been, I would say, very pleased with the recoveries that we've had to reimburse our costs of arbitration and legal fees and expenses. And I personally view that as a strong plus for arbitration. And with that, I've talked, I think, more than long enough, and again, happy to try to answer any questions, but I'll pass the podium over at this point.
Yeah, I think we take questions and have discussions after we heard from Professor Inge Schwenzer about the more substantive part of an international sets contract.
Okay, thank you very much, Petra. I thought that we might go through the most important substantive clauses in a contract, and usually, from my experience, if you have a contract that is litigated or arbitrated, most of the time the relevant questions center around non-conformity of the goods, including under the CISG, did the buyer give adequate notice of any non-conformity? Then remedies, especially calculating damages, or was there a fundamental breach so that avoidance was possible? And then all the clauses relating to liability. Then also very important all the time is one party, the breaching party, exempted from liability, be it that there was a force majeure or be it that there was hardship. Actually, I did have accidentally 2 arbitrations on hardship in 2009. You may imagine why, because the markets were rising, so especially the commodities markets, and naturally sellers didn't want to perform for the contract prices they had contracted for. So this becomes highly relevant. Last point, interest, we could discuss it. and limitation periods, because the CISG does not contain a limitation period. So this is also a very core provision in a contract, that you think about the relevant limitation period. I have copied the relevant provisions here. First, the nonconformity under Article 35. If you have a look at Article 35, Par 1, it clearly states the seller must deliver goods which are of quantity, quality and description required by the contract and which are contained or packaged in the manner required by the contract. So it is first and foremost up to party agreement what they define as conformity of the goods with the contract. So let's first turn to quantity. That seems clear, but in many contracts, especially in commodity trade, you may agree on possible tolerances. For example, there are also trade usage to that effect. For example, in the steel trade, there is a usage that the seller may deliver either 5% less or 5% more than the quantity contracted for. But usually you are very well advised, if you put it into your contract, whether there should be any possible tolerances. Quality of the goods, these relate to the features of the goods. That is usually very detailed in the contract, but also to their origin, where they come from. This may be very important if you, for example, if you have some trade bans or the like, or also, for example, if you are an ethically, if you have some ethical standards that you want the goods to adhere to. What is also very important are manufacturing practices. They become more and more important in many parts of the world. It is more important that you can prove how the manufacturing process was, that you had certain quality controls. It is more important than the real features of the goods. I have had cases where you didn't even look at the goods at all. There were some documents missing relating to the manufacturing process, so you just had to destroy the goods. That was all. You cannot market them, you cannot put a certain stamp on them. Especially, probably you also have seen here, in the European Union there is the CE stamp, and you can put this stamp on a product only if you have seen the relevant document concerning the construction process. Otherwise you're not allowed to put this CE mark on it, and without a CE mark you cannot market the goods. So you just have to destroy them. What is also important, if you do have in your own country or in the buyer's country, if you do have certain public law requirements, like for example, let's assume you have an American buyer and he wants to market the goods in the United States. Then you should make clear that the goods live up to your public law requirement. And if the seller does not want this, and if the seller does not agree, then as a buyer you might have to inquire what your public law requirements are and to spell it out in the contract that the goods do live up to these requirements. Then Article 35 Par 1 mentions packaging, so this also might be taken care in the contract itself. For example, if you need a certain packaging of the goods. Furthermore, there may be additional duties that you want to spell out in the contract, especially services or non-competition clauses. In many contracts, in many more complex contracts, besides the delivery of the goods, you have services obligations. For example, take a case that was also an arbitration that I had myself. There was a whole peninsula with a desert. There should be telephone wires for this whole peninsula. In the Middle East. So the seller was not only obliged to deliver the poles and the wires that could be used in the desert with the desert storms and everything like that, but he also had to train the personnel of the buyer who was supposed to put up these poles, and afterwards to supervise the work done by the personnel of the buyer. So what in the end happened, you can imagine, the wires didn't function, broke down, the whole system broke down. Now it was disputed, was it the wires, because they were not fit for this particular purpose, namely be used in the desert, or was it the training of the personnel of the buyer, or was it the supervision that was this obligation that was breached? Fortunately, under the CISG, you don't have to distinguish between them. As long as the services part is not the preponderant part of the contract, so long you're in the CISG and everything can be treated under Article 35. So it does not matter whether the services part of the obligation has been breached or whether the goods did not conform to the contract. In this respect also, if you have a mixed contract, you are well advised to spell out in the contract itself how many percent pertain to the services part of the contract and how many percent to the delivery of the goods. Then in many cases this is something like 5 to 10% to the services part and the rest to the goods. Then you are on the safe side, and then you are inside the CISG. Article 35, para 2, if the parties have not explicitly spelled out in their contract the questions relating to quantity, quality, and the like, then Article 35.2 gives us some objective criteria. In litera A, you have, and this might sound very familiar to you with the Sale of Goods Act, you have the fitness for the ordinary purpose, and in litera B, you have the fitness for a particular purpose. So at least if you do not agree in your contract itself on specific features of the goods, make sure as a buyer that you bring the particular purpose you need the goods for into the contract. In my case of the telephone wires, that was the prerequisites for wires to be installed in a desert. So they had a climate charge and everything, so that the seller could know what they were used for. This provision may also be used when it comes to public law requirements. If you have not, as a buyer, told the seller which public law requirements apply, then by putting into the contract where the buyer wants to use the goods, that might amount to a hint for a particular purpose. So at least if the seller is the more knowledgeable, if the seller itself manufactures the goods, that the seller, it is upon the seller to inquire about the public law requirements in the countries the goods shall be used. Then there are further objective criteria the goods have to live up to, namely if there is a sample or model, the goods have to conform to this sample or model in the positive as well as in the negative. There is case law out there where already the sample did not function, so whereas the goods conformed to the sample, the goods were conforming and not non-conforming. So it works both ways, for the buyer on the one hand and for the seller on the other hand, in cases where the sample itself is defective. Finally, if the parties have not spelled out anything concerning packaging, then the packaging must be adequate. The CISG, unlike many domestic legal systems, requires the buyer to examine the goods, and if upon examination of the goods the buyer discovers that the goods are non-conforming, or should have discovered by a proper examination that the goods are non-conforming, then the buyer must give notice to the seller of such a non-conformity. If it does not give notice, the consequence of such a lack of notice you find in Article 39, Para 1, namely the buyer loses the right to rely on a lack of conformity if the goods if he does not give notice. So the consequences either of not properly examining the goods and therefore not being able to give notice, or of just not giving notice, are rather severe. The buyer loses any right to rely on a non-conformity of the goods. So, if you look at Article 38, Article 38 does not give us many hints how the buyer has to examine the goods. It only tells us when the buyer must examine the goods. It states in Para 1, the buyer must examine the goods or cause them to be examined within as short a period as is practicable in the circumstances. And Para 2 and 3 contain provisions when the buyer may postpone the examination in case of carriage of the goods or in case of a redirection of the goods. So, what should the parties agree to specify this duty of examination? First of all, they may agree in their contract upon the methods of examination. Who is to examine the goods? In many cases, especially if you have more complex machinery, or let's take, for example, a whole plant, a paper mill, or the like, then the parties in many cases agree to examine the goods together. They have a certain examination process, personnel from the seller comes to the buyer, and they have certain procedures. For example, the machine has to work for a certain amount of hours, and they are taking protocols to keep the results. Then, furthermore, a contract should provide for the period of examination. When should examination start? How long should it last? And so forth. When it comes to notice, the notice requirement in Article 39, we have again a certain period of time. Please have a look at Article 39. It reads, the buyer loses the right to rely on a lack of conformity if he does not give notice to the seller specifying the nature of the lack of conformity within a reasonable time after he has discovered it or ought to have discovered it. There are several points in Article 39, para 1 that should be mentioned. First of all, the notice must be specific. It must clearly state the non-conformity and not just in a general way like, well, we were dissatisfied with what you delivered. So the parties in their contract may spell out what is a specific notice. So what does the buyer have to tell the seller? Furthermore, they are well advised if they agree on what exactly is the reasonable time. Usually nowadays, if there are no other indication, especially if the goods are not perishable or the like, then many courts in different countries now would agree that 1 month from the discovery of the non-conformity until the giving of notice would be such a reasonable time. However, to avoid any risk, again, I think the parties are well advised to specify in their contract what they presume to be a reasonable time. I've seen many contracts where it was spelled out that the buyer should give notice within 1 week or 2 weeks after having discovered the non-conformity. Just a short hint to Article 39, para 2. There we have a 2-year cut-off period. It states, in any event, the buyer loses the right to rely on a lack of conformity of the goods if he does not give the seller notice thereof at the latest within a period of 2 years. However, I just want to advise you, this is, although it looks like on the face, but it is not a limitation period. So do not rely on this 2-year period. You are well advised, either as seller or as buyer, to specify a certain limitation period. Let me briefly turn to the possible remedies and mention what you should consider in drafting a contract, whether you should modify these remedies. First of all, the CISG follows the so-called breach of contract approach. That means the remedies are not structured regarding the reason for the breach, as it is the case in civil law legal systems, but each breach of contract triggers the same remedies, and they are, well, the difference between them may be the question whether we have a fundamental breach or not. Remedies are available under the CISG in general. First of all, any party may withhold its own performance if the other party has not performed. Second, unlike in common law countries, we generally have the right to specific performance, which, however, does not have to be granted by a court in a legal system where it would not grant such a remedy in cases if they were to be decided under its own law. Then, just like the common law legal systems, in any case of breach of contract, we have a right to damages, and then the aggrieved party may avoid the contract. However, we do have a certain threshold, namely avoidance that may lead to the consequence that the goods have to be transported back to the seller. Avoidance is only possible in cases of a fundamental breach of contract, a breach that goes to the essence of the contract. And finally, we have a remedy that comes from civil law legal systems, namely price reduction. And this is important, this remedy of price reduction, especially in case of non-conformity of the goods, be it that there was a lesser quantity than contracted for, or that the goods otherwise were non-conforming. The price reduction mechanism is important in cases where the seller is exempted from its liability for damages under 79. So there may still be the possibility to reduce the price, although the buyer may not get damages. Let me briefly turn to the different remedies. First of all, I have here Article 46, the right of the buyer to require performance from the seller. First of all, I want to mention that according to Article 4, litera A of the CISG, the questions of validity of the contract as a whole, but especially also validity of certain contractual clauses, is not governed by the CISG. This validity is governed by domestic law. So whenever you are drawing up a clause that varies, modifies the remedies under the CISG, you must be aware which law, which domestic law governs the contract which is supplementing the CISG. Because this law that is otherwise applicable to the contract will govern the validity of these clauses. I right now have a case between a Chinese seller and an Italian buyer. And the Chinese seller obviously got a contract form, I don't know where from, I think from the internet, and he has a limitation of liability clause in this contract form. This limitation of liability clause is obviously modeled on the American Uniform Commercial Code. However, the parties being Chinese and Italian, both legal systems have been very much influenced by German law. So the parties chose German law as the governing, including the CISG, as the governing law of their contract. What they obviously did not know, I think both parties didn't know, is that German law is rather strict when it comes to the control of standard terms. And so this limitation of liability clause, being perfectly in line with the American UCC, is totally void under German law. So please, whenever you draft such a clause, have in mind which is the applicable domestic law governing the validity of this clause. So what should you think as as counsel for seller, but also for buyer. Well, you may modify the remedies. You may exclude certain remedies, like, for example, specific performance. You may provide, like, for example, if you have a look at Article 46, there you have the choice of the buyer. The buyer may elect whether it asks for repair or replacement of the goods, or whether it turns to other remedies. Here you may reverse the election mechanism and give the seller the right to elect which remedies it wants to perform. Furthermore, what is also very important not to run any risks. I told you avoidance under the CISG is possible if the breach amounts to a fundamental one. So you may define in your contract this threshold for such a fundamentality of the breach. For example, in case of a delay, be it with a purchase price or delay in delivery, you may define that upon a certain date the breach is a fundamental one, and then the other party, the aggrieved party, has the right to avoid the contract. On the other hand, you may provide in the contract for a period of grace. Under the CISG, we do not have such a possibility that the party in breach is given a period of grace. However, as the parties may deviate from the provisions of the CISG, they can always give such a period of grace. Finally, shall I come to a... Okay. Finally, what you find in every contract are clauses relating to damages. The starting point, wait a second, I should have it here. The starting point for all consideration is Article 74 of the CISG. According to Article 74, you have the full compensation principle. That means that all losses are recoverable under Article 74. Article 75 then contains a provision regarding compensation if one of the parties has made a cover transaction, a concrete cover transaction, whereas Article 76 gives the aggrieved party the possibility to calculate its damages according to the market price. So, what are the possibilities of the parties under Articles 74 through 76 to modify the damages under the CISG? First of all, the parties may exclude certain losses. Very often they want to exclude, for example, loss of profit, which may be considerable. They may also want to use certain caps, that they say loss of profit can only be asked until $1 million or the like. Then, especially civil law, parties from civil law countries for whom the concept of the CISG of strict liability is a bit unfamiliar, they might take a fault principle into their contract. that a party is liable in damages only if there was fault, negligence, or even gross negligence on their side. Furthermore, in most contracts, you find so-called, fixed sums, to use a neutral word. For you common law lawyers, you better understand these clauses either as penalty or liquidated damages clauses. In common law, you distinguish between penalties. Penalties are void, whereas liquidated damages are fine if they are an adequate pre-estimate of the loss. In civil law legal systems, you do not have this distinction between penalty clauses and liquidated damages clauses. All fixed sums in principle are okay. If the clause, if the provision, the sum is too high, it may be, however, reduced by the court or the adjudicator. So in most contracts you find such clauses. Usually they relate to delay, especially, that you spell out for each week of delay, be it with paying the purchase price or also with delivery of the goods. The party in breach has to pay a certain percentage of the purchase price, and usually these clauses contain a cap until we reach, let's say, 10 or 15% of the whole contract price. So I think I stop here. I could go on. I have force majeure and hardship clauses, but I think that's fine for the moment. Maybe we come back to the other clauses during the discussion.
Fantastic. Thank you so much. And I open the floor for any questions. Anybody can come up with some contract they're looking at the moment. That's your chance now to ask. Any questions? Otherwise, I have. No, David.
I have one for David and probably two for Professor Schwenzer. David, just on the things that you look at as corporate counsel, and I know you're not wearing the corporate counsel
David,
hat.
can you maybe stop and repeat? We need a microphone for you. Otherwise, we can't hear you on camera.
So David, just in terms of what corporate counsel look at, and in light of comments made earlier in the arbitration portion of this conference, the accessibility of appeal, how attractive is that to corporate counsel when they're selecting their arbitration clause? Because obviously, as Justice Chambers outlined, you could have possibly 8 further substantive hearings.
Yes, I thank you for that question, David. I was overjoyed by the judge's comments because, as I intimated and perhaps didn't express this as clearly as I would have liked to, you choose arbitration because you're hoping that with a little care and forethought, it will be confidential, relatively quick, and final. And you have to, I think, have the courage of your convictions to say, it is going to be final, not only if I win, but also if I lose. And to, as we heard the Justice say, to have a situation where, like Casatas, which went on for 3.5 years or some, over an issue of costs, which was never addressed by the arbitrators, never, as I recall, the case requested or demanded by the parties. That is, in my humble view, hindsight being 20/20, that's intermeddling by the courts. And there was a recent decision in Australia that causes me some concern as well, that the courts are essentially saying, in so many words, we are going to reserve our rights to interfere where we have concerns that substantial justice is not being done, etc. That's not why, in my view, parties go to arbitration. So finality is hugely important to me. And I said before, but it's worth repeating. That doesn't mean that I do not use words like quick and dirty when I'm talking about arbitration. I want a robust process that pays attention to accuracy and fairness, etc. But if it can be a bit faster than the courts, well, I think that's good.
Thank you.
May I just add a few words? I'm coming from an arbitration-friendly country, so you only have the possibility, if with very restricted grounds, to go to the Supreme Court of Switzerland, which renders a decision rather fast. It takes you about, well, I have experienced three to 5 months. You get a decision. But still, I mean, reality may be very different, and it depends upon the parties. I mean, I'm right now in a case where we have two different, one ad hoc investment arbitration and a commercial arbitration relating to the unwinding of the joint venture between two private parties. And I don't know, we have something like 8 or 9 cases pending. We up to now, our side won. I'm counsel on that one. Our side won everything, but you can have you had set aside proceedings. One award, set aside proceedings. Then there's a possibility under Swiss law, if new facts are discovered, you can have a revision. So revision proceedings, and then now we have just a second arbitration, a second ICC commercial arbitration starting. And I wanted to mention that there it's also very important. I would agree. The seat selection is so important, because in this case the procedural law of the seat has to determine whether there is res judicata or not. So all these questions are very important. And our side is trying to enforce the first award with pending procedures at the German Supreme Court, after having had two tiers of proceedings in Germany and others in New York. So whatever, that far, the finality of the award, it's taken now 8 years.
Yes. These are relativities and generalities that we're speaking of, to be sure. And I would just jump in again. I often sit as arbitrator in Singapore and Hong Kong, and in Singapore in particular, Rule 28 gives the tribunal 45 days to prepare a draft award and get it off to the registrar. When it's your Christmas holiday and you're sitting there doing the typing, well, that's a very short period of time. But more frightening from an arbitrator standpoint and the party standpoint, if I'm recalling correctly, the Taiwan Arbitration Act has a similar deadline for the issuance of awards, and it's jurisdictional. If you exceed that, the case is over, the tribunal becomes functus, and the parties are going to be very unhappy. So these time limits, or fast tracking, or modifying agreements to impose very short time limits on a tribunal, you got to be very careful, because they can come back to bite, I think, sometimes.
David, you had another two questions.
I can wait.
Okay. Luca?
Just to be innovative, to say that, of course, it is a shared concern now. Also, there were some changes in the ancillary arbitration rules and arbitration rules, so both to keep timeline in mind and to reduce costs. So there is an institutional response that now making this possible. To ask for an estimate of the cost, to have a review of the cost by the appointing authorities, but also to ask for a timeline as well.
Thanks. Dr. Schwenzer, just on the rather unfortunate habit of New Zealand lawyers not being as familiar with the CISG as they might be, a lot of them will tend to contract out. But in practice, as I understand it, that requires an explicit statement of contracting out, not simply a choice of law. So in a lot of instances, the CISG will continue to apply, but the domestic law contract will also be applicable if it's New Zealand law chosen. Is that correct?
That is correct. Nowadays, it is almost the unanimous view that the designation of the law of a CISG contracting state alone is not enough to opt out from the CISG under Article 6. You must explicitly state, for example, New Zealand domestic law is chosen to govern the contract, or the Swiss Code of Obligations shall govern the contract, to effectively vote out of the CISG. If you choose the law of a non-member state, like English law, that means that you are contracting out, opting out from the CISG. Another question is, we will have an opinion on this question, because it is rather important, especially in Australia, but also in France, is if the parties have been litigating under the wrong law. That means a New Zealand and an Australian party litigating or arbitrating and then litigating in the High Court, and nobody ever mentioned the CISG. The question is, and this has been decided differently by different courts, does that amount to an implicit opting out from the CISG? I may already say, the CISG Advisory Council does not think so, because ignorance is not a choice of law.
And I second that. I can say I've got a statement of claim back at the office on my desk that has been sent in from someone completely ignorant of the fact that the Sale of Goods Act doesn't apply, and that would not be something we'd be prepared to waive. The operation of the CISG, of course, applies. And of course, that will also extend to things like Contractual Remedies Act claims. There's other statutes, of course, in New Zealand that might relate to the obligations of buyer and seller, but of course, those will also be excluded by the operation of the CISG.
Yes, I mean, as far as the CISG goes, it preempts any domestic law.
Do you have another question? Any more questions? And I actually have one in regard to the quality of the award. Can you define a little bit what a quality award is? Because it's actually quite interesting talking to different arbitrators in council what their ideas of a quality award seems to differ relatively quite a bit among arbitrators in council, also depending on the discipline they're doing. So construction, the amount of the award is the amount what is at stake. What is a quality award for you?
Well, I can give you a personal opinion. I mean, there have been court decisions out of Australia and no doubt other jurisdictions talking about what a reasoned award requires. But my personal view is I would expect nothing less full and complete in an arbitral award than I would in a court judgment on similar issues. So I would expect it to be very expansive and talk about what evidence was offered up and how it was analyzed and viewed, and witness testimony the same, and applicable law and the reasoning and the application of that law to the decision. And of course, key to any arbitral award is it has to answer every question raised and not any questions that were not raised. So it can't be what infra petita or ultra petita, and so it does require a degree of care, but that's what I would be looking for personally.
Do you have?
I think I do not have to add much. I would perfectly agree. What is also very important is that it takes up all the questions that have been discussed, but doesn't go further. For example, if you want to apply a certain provision, even let's say by analogy, you have to discuss it with the parties, with counsel, at the hearing, and not take them by surprise. Actually, there was an award overturned by the Swiss Supreme Court. I think it was three years ago or so, on this very ground. A CAS, a sports award, probably you know it.
That was an excellent point, Professor, and there was similarly a case out of Hong Kong within the last 12 months involving, among the three arbitrators, a very prominent New Zealand arbitrator, where again, a highly experienced tribunal ran into the same sort of trouble by relying on some cases. I think there were some Taiwan cases that had not been, counsel had not been given an opportunity to be aware of them and to speak to them. And often, I mean, I've had a couple of cases myself, appointments where the arbitration agreement will specify that the arbitrator has to have a record of experience in IT and technology matters, for example. So, on the one hand, it appears to be the clear intention of the parties that they're looking for an arbitrator with a certain specialist background. But again, to that point, how far do you want to, in drafting your award and reasoning it through, rely on your specialist experience without ensuring that the parties see where you're going and have an opportunity to speak to it and address it. So it's a difficult balance, I think.
Any more questions? Well, if nobody has questions anymore, I think afternoon tea is more or less waiting. And I would like to invite anybody. I mean, I would like to acknowledge, because I forgot that when I started, the support of the Law Foundation. Without, we would have not actually anybody here, really. But I also think it's time now to actually thank our two presenters for the excellent presentations and answers we got.